Justice of India, Surya Kant, has taken serious objections to a new Class 8 social science textbook released by the National Council of Education, Research and Training, which includes reference to corruption at various levels in judiciary. In open court today, the CJI confirmed he has already passed an order taking suo motu cognizance of the issue, saying he will not allow anyone to taint or defame the integrity of the institution. The controversy centers around a chapter in the NCERT textbooks on the role of the judiciary in our society. The chapter flags judicial corruption and systemic delays as structural challenges facing India's courts. According to the textbook, the Supreme Court of India currently has about 81,000 pending cases, while high courts together are burdened with approximately 6.2 million pending cases. District and subordinate courts account for nearly 47 million pending cases, highlighting what the book describes as a massive backlog in justice delivery system in India. The chapter attributes delays to a shortage of judges, complex legal procedures and inadequate court infrastructure. It also explains that judges are bound by a code of conduct governing professional and personal behavior and outlines internal accountability mechanisms within the judiciary. Importantly, the book notes that citizens can file complaints through centralized public grievance redress and monitoring system, and states that have over 1,600 judiciary-related complaints were received between, in fact, 2017 and 2021. The chapter further quotes former Chief Justice of India, B.R. Gavai, who in July 2025 observed that corruption and misconduct harm public confidence in judiciary and that rebuilding trust requires swift, decisive and transparent action. The issue was mentioned before CJI by senior advocate Kapil Sibal, accompanied by senior advocate Abhishek Manu Singhvi, who said that members of the institution were deeply disturbed that such content was being taught to Class 8 students. Singhvi also questioned what he termed as the selectivity of the content, pointing out that there was no similar reference to corruption in bureaucracy or in politics. Responding firmly, CJI Surya Kant stated that lawyers and judges were perturbed and that he has received multiple calls from judges across the high courts. This now sets up a significant institutional moment for India as the Supreme Court examines whether a textbook discussion of judicial corruption and backlog is an exercise in civic education or crosses into institutional denigration. Joining me on the show is Tarun Rana, advocate, and he's also the secretary of the New Delhi Bar Association. Also with us is Sanjay Chadha, a senior advocate for Supreme Court of India. Also with us is Professor C.B. Sharma. He's an educationist. Let me first come to you, Mr. Rana. The question that we are essentially asking today is that mentioning backlogs and complaints against judiciary and an institution, is it a lesson in civic awareness, or do you believe it crosses a line here?
Well, today only when I read this news, streaming on the social media, that NCERT book of Class 8 having a chapter of the role of judiciary in our country. So far as that chapter is concerned, it's okay. But further, there are two classifications. One which says about the backlog and the other one points out the corruption in judiciary. So this is really disturbing, because pointing out the corruption in judiciary and teaching this lesson to the young students, this is really disturbing. And if the Honorable Supreme Court has taken a view on that, as a representative of the bar, we would say that the bar and bench, both are the wheels. Bar and bench are two wheels of a same chariot who are responsible for and involved in the dispensation of justice. So we cannot point out, we cannot teach that there is a corruption in judiciary. There may be various reasons for backlog.
No, one second. Are you saying there's no corruption in the judiciary?
No, I'm not saying. I'm saying we cannot teach this. We cannot say that there is a corruption in judiciary.
Why not?
Because reason being, still in our country and everywhere, this is a system where every common man has a faith in the judicial system.
Okay.
When there is any dispute and it is not amicably settled, So there is a perception, there is a belief in the for the common man. Yes, we can have the justice. There may be n number of reasons that there are backlogs. There are so many reasons. It cannot be attributed only to the judicial officers or the or the lawyers. There are so many. There may be. So we need to have the reforms. We need to go through that. What are the all the administrative reforms we can make to expedite the delivery of justice?
My question is, let me take that from Sanjay Chadha ji. Mr. Chadha.
No, I may clarify. I
Yeah.
understand what was your question. What I am referring that we cannot point out. We cannot say that there is a corruption in judiciary.
I'm not sure why we can't say that.
It is very alarming if it teaches the young student that there is a corruption.
Why? It's our right to, students should be taught if there is a problem with a public institution so that they can question that public institution so that we can make it better. The entire idea of teaching people or teaching young people that there is a problem with a certain institution is to strengthen that institution, sir.
No, then it would be then we will lead to a situation. Then someone will point out there is corruption in judiciary. Someone will say there is a corruption in bureaucracy. Someone will say there is a corruption in politics. So everywhere, and we cannot teach in the. Just bear with me. What we are doing, that if we have made a syllabus in the textbook, then it is very alarming. Having a debate, pointing out in a public forum, that is a separate issue, but we cannot teach the student. It cannot be a subject matter of a NCERT.
I don't necessarily agree with you, sir, but let me take that question with Sanjay Chadha. So I'll come to you. Give me a minute. I'll come to you. Let me go to Sanjay Chadha ji. What is the problem, Mr. Chadha, in pointing out that there is corruption in a certain public institution? Does questioning an institution weaken it, or does it make it stronger? The entire debate is about whether we ask questions of an institution. Are we trying to bring it down? Are we trying to denigrate it, or are we trying to make it stronger? Because that's the idea of question. Until you question a system, it does not improve.
There are two differences. I agree with what Tarun had said, but I am totally agreeing with you also, stating that we should question. We should question, no doubt about it. But there is a big but here. We are teaching 8th standard student who is going to grow up in this system, first of all. Secondly, when he will grow up, his confidence in the judiciary will be shaken reading this, that there is a judicial corruption, there is a huge pendency of cases, everything is negative. His confidence from the childhood will not be there in the institution. Now, very important that we as a country in India, you just see, majority of people, if you ask today also, despite, we remember that Justice Verma's case where money was found in the backyard of the house. Despite all that, you ask, I can challenge this, you ask anybody that from where you can get the justice, these temples will be remembered, number one. Number two, very categorically I am saying that this trust, we are governed by rule of law. If the public trust goes, the rule of law will, it will be also not be effective, number one. Number two, yes, we can question, as you said, but this is not the right place to question.
Okay, what's the right place to question?
Right place is, we can not at the childhood, but in the syllabi itself, there are so many cases are there.
So tell me, if class 8th is not okay, is class 10th or class 12th okay?
No. Please allow me. No, don't put your words.
No. You said class 8th is too young.
No. It's too young.
Okay. So tell me, is class 10th okay to be taught about judicial corruption?
Please allow me to finish it.
Okay.
No, I'm not saying so. What I'm saying is, we should have, even at this stage, what are the causes of pendency? Positivity should also be shown. If you are showing that why the cases are pending first, what are the judicial reforms needed, how to implement, how to fill the vacancies, what is to be done for increasing the infrastructure. All those things should be.
So that's happening
in a-
parallelly. Would you agree that government is doing that parallelly? Judiciary is also doing that parallelly. It's trying to reform. The government is trying to reform the judiciary. The judiciary
I
itself is
feel-
reforming. No?
I'm being very blunt on it. I feel whatever is required is not done.